The Supreme Court chamber fell silent as Justice Amy Coney Barrett leaned forward, her gaze fixed intently on former Florida Attorney General Pam Bondi at the podium. What began as routine oral arguments in a pivotal constitutional case had turned into an unexpected confrontation. Barrett, known for her typically measured judicial temperament, broke from her usual restraint. "Miss Bondi," she began, her voice echoing through the quiet room, "your constitutional argument contradicts established precedent in at least 3 major decisions. Perhaps you should familiarize yourself with Harrington versus Davis." Her dismissive tone drew subtle reactions from the other justices. Bondi, representing a coalition of states in a high-stakes federalism case, stood momentarily frozen, but Barrett wasn't finished. "Your interpretation of Article 3 jurisdiction seems fundamentally flawed. How do you reconcile this position with your previous legal writings?" Barrett's words carried authority, and all eyes were on Bondi, the newly appointed lead counsel for a monumental case, Federation of States versus Department of Commerce. At stake was whether recent federal regulations had overstepped state sovereignty, particularly in areas like taxation and land use. For Barrett, this case represented an opportunity to further her originalist judicial philosophy, especially as the court's conservative majority seemed increasingly willing to revisit precedents. Bondi, however, came at the case with a practical edge, honed during her tenure as Florida's Attorney General. Despite her limited Supreme Court experience, she was determined to prove her mettle. What came next shocked everyone in the chamber, including the usually unflappable Barrett. Bondi responded with a counter-argument so precise and well-researched that it not only silenced Barrett's critique, but made the justice reassess everything she thought she knew about the case. This remarkable legal showdown would go down in history. "Thank you for that question, Justice Barrett," Bondi said, her voice calm despite the sharp critique. "I'm quite familiar with Harrington, and if you'll permit me, I'd like to explain why it actually supports, rather than undermines, our position." Barrett raised an eyebrow, signaling for her to continue. Bondi cited specific language from the case, referencing Chief Justice Reynolds' narrow reading of the Commerce Clause and Justice Kavanaugh's controlling concurrence. "Applying that test to our current facts reveals a crucial distinction," Bondi said, her tone gaining confidence. As she continued, Barrett's interest visibly piqued. Bondi smoothly transitioned to another lesser-known case, Westmoreland versus United States, where the court had invalidated federal regulations that failed to meet the tailoring requirement established in Harrington. Several justices exchanged looks as Bondi deftly navigated through these precedents, impressing even the more skeptical members of the court. "Counsel Westmoreland was a Tenth Circuit decision," Justice Sotomayor interjected, "not a Supreme Court precedent." "That's correct, Justice Sotomayor," Bondi replied without hesitation. However, this court cited Westmoreland in Montgomery v. Louisiana when discussing the limits of federal regulatory authority in areas of traditional state prerogative. Bondi's expertise was on full display. Barrett, now visibly intrigued, asked, "Are you suggesting that Nickvika Township of Scott extends to the broader federalism context we're discussing today?" "Yes, Justice Barrett, but not through simple analogy," Bondi answered, proceeding to explain how Nick's reasoning had been applied to cases beyond property rights. The dynamic in the room had shifted. What started as a challenge from Barrett to expose weaknesses in Bondi's argument had evolved into a high-level constitutional dialogue between 2 formidable legal minds. The justices, once passive, now began asking follow-up questions, which Bondi answered with remarkable precision and depth. Even Justice Kagan, known for her incisive questioning, appeared impressed by Bondi's ability to distinguish between seemingly conflicting precedents. Barrett, now genuinely curious, asked, "Miss Bondi, if we accept your framework, how would you suggest we articulate a limiting principle to avoid misapplication in future cases?" Bondi calmly outlined a 3-part standard that would balance state sovereignty concerns with legitimate federal interests. Her proposal was so detailed that it addressed potential objections before the justices could raise them. As the Chief Justice announced that Bondi's time was nearly up, an unusual moment occurred. Barrett requested that Bondi be granted extra time to finish her analysis. This rare procedural courtesy signaled the court's engagement with Bondi's arguments. When Bondi returned to her seat, observers in the gallery buzzed with whispered assessments of what they had just witnessed. The Solicitor General representing the federal government hastily revised his planned remarks, clearly recognizing that the legal battle had become significantly more challenging than expected. The impact of Bondi's performance reverberated far beyond the court. Legal scholars immediately began analyzing the exchange, with many noting the sophistication of Bondi's arguments. A prominent liberal legal scholar tweeted, "Regardless of where you stand on federalism, Bondi's command of precedent and constitutional theory was masterful." Inside the Supreme Court, the justices' deliberations reflected a shift in dynamics. Barrett, in an unusual move, reportedly told her colleagues, "Ms. Bondi's analysis of the federalism precedents requires serious consideration." What had once seemed like an open and shut case for the federal government was now much more competitive. 3 months later, when the court issued its decision, the states prevailed in a 6-3 ruling. The majority opinion, written by Justice Gorsuch, referenced several of Bondi's arguments directly. Even more remarkably, Justice Barrett wrote a concurring opinion that engaged with Bondi's analysis, acknowledging the persuasive application of Bondi's legal reasoning to the case at hand. Legal observers hailed this as an unprecedented acknowledgment of an advocate's influence on a justice's thinking. Law professors immediately began referring to this case as the Bondi test, a new 3-part standard for evaluating federal regulations that impact state functions. Beyond the specific case, the exchange between Barrett and Bondi entered legal lore. Law schools began using recordings of the argument to teach advocacy, highlighting Bondi's exceptional preparation and Barrett's intellectual humility in reconsidering her initial assumptions. The moment had become a powerful reminder that in constitutional law, the most significant legal advances often arise from thoughtful reconsideration, not from confirmation of existing beliefs. Months later, Barrett and Bondi appeared together at a Federalist Society event discussing the evolution of federalism jurisprudence. Both spoke with respect for each other's intellectual rigor, demonstrating how their courtroom encounter had transformed into mutual professional respect. Barrett commented, "The most valuable moments in constitutional development often come when our assumptions are challenged by advocates who approach legal problems from different perspectives." Bondi responded, "The strength of our legal system depends on rigorous testing of ideas, regardless of their source. When justices and advocates engage in good faith, constitutional principles are refined and clarified." The legacy of their encounter had a lasting impact. Bondi's career flourished, with law firms and law schools seeking her expertise. And the legal world recognized that underestimated advocates, like Bondi, could reshape the landscape of constitutional law.